Hello, welcome to this instalment in our series on Introduction to Judicial Review. I'm going to be looking today at drafting grounds for judicial review. And I know that you've already heard, or if you followed the series through, you've already heard a little bit about, in terms of the initial procedure for judicial review, how to commence a claim, and also what documents you need to include with your claim form when you file it. So I'm going to focus on what we typically call a statement of facts and grounds for judicial review. Now, first question is, well, what is that? Well, in terms of what it has to be, you need to look at Practice Direction 54A in the Civil Procedure Rules, and particularly paragraph 4.2, which talks about the contents of the claim form. Now, what it says is the claim form needs to be accompanied by the following. The first is a clear and concise statement of the facts relied on set out in numbered paragraphs, and a clear and concise statement of the grounds for bringing the claim, which is called the statement of grounds. And the practice direction goes on to say the statement of grounds should identify in separate numbered paragraphs each ground of challenge, identify the relevant provision or principle of law said to have been breached, and provide sufficient detail of the alleged breach to enable the parties and the court to identify the essential issues alleged to arise. The statement of grounds should succinctly explain the claimant's case by reference to the statement of facts and state precisely what relief is sought. And then the practice direction says that those two things, the statement of facts and the statement of grounds, can be in the same document. And in practice, that is generally how it's done. And certainly that's what I would recommend, because as they say there, you often want in your statement of grounds to refer back to what you said in your statement of facts. And it's just easier for the judge if they're in the same document, and it's easier for you to cross-reference in the same document. And probably as an exercise, if you're drafting them both together, you're more likely to have them all in mind when you do so. The final thing that the practice direction says about the statement of facts and grounds is that the statements of facts and grounds should be as concise as possible. The two documents together, or the single document, if the two are combined, shall not exceed 40 pages. In many cases, the court will expect the documents to be significantly shorter than 40 pages. The court may grant permission to exceed the 40-page limit. Now, it's often said, and I think very important in this case, to remember that that page limit is a limit and not a guide. The practitioner tells you to be concise, and it's absolutely in your client's interest to be as concise as you can. So as a rule, as a general rule, in my experience, you're unlikely to want more than 20 pages for your statement of facts and grounds, and you may well go well beneath that. As I said, as a general, each case will be different, but you want to aim a long way below the 40-page limit, in my opinion. You've got to remember, first of all, that your statement of facts and grounds, it's a very important document for your claim, because the first stage of any judicial review claim is a permission stage. You've got to get over that page, that line, if you like, and that stage is decided, at least in the first instance, by a judge on the papers. So you're not there to speak to your statement of facts and grounds. It has to do all the talking for you, and it has to persuade the judge that your claim is arguable. And a judge who's looking at permission applications often has a significant number of applications to get through. They've only got a limited time to do it. Almost certainly they're under some degree of time pressure, and you have to persuade them effectively that your claim is one that's worth listening to. And a good start is to be concise and not unduly long in the submissions that you make, because that will just annoy them and probably won't set yourself up for a good start. So my view is being concise helps your claim to be persuasive. And another point is that the longer it takes you to explain what's gone wrong in your case does tend to indicate that the error is much less obvious and perhaps less arguable. And if you can explain it briefly, more likely it's a big error that the court's going to really sit up and think, oh, right, that is of interest, that is arguable, and grant permission on it. So do really make an effort to be concise. Certainly in my experience, I found it helpful, both bringing and defending claims, because often defending claims that are very, very long actually gives you quite a lot of opportunity just to say really that the claimant is waffling. There's a sort of scattergun approach, taking every bad point, and actually that you can often portray a long claim as a claim challenge to the merits, whereas an error of law should be something quite clear often and simple. As I said, these are general rules. So how do you go about structuring a statement of facts and grounds? Well, aside from those essential, those fundamentals that you have to put in, it's really up to you how you go about structuring it. It's a matter of style and good practice. So what follows here is essentially my recommendations, but there's nothing mandatory about it, and many people, I've no doubt, do it differently, and I'm sure some do it better. So how I'd recommend doing it, well, first of all, you start with the title of the proceedings and the title of the document. That's all pretty standard stuff. And then what I typically do is, before I go into the text, I'd have a section where I set out how I've referenced the bundle, for example. So if I've included page references in the statement of facts and grounds, what they mean, what they're referring to. And I will generally include a list of essential reading in there as well to help the judge who's looking at this for permission. They're going to want to be directed to those documents that they really, really have to read. And to know those ones that maybe they don't need to read just for the purposes of permission. So I'll put that in. And also I try to include a time estimate for reading time. How long do I think it'll take the judge to read the relevant papers in the case? Because it potentially it can help if the judge is busy, then to know, well, okay, they're saying this is going to take me 1.5 hours. At least they've got an indication. Obviously, you know exactly how quickly a judge is going to look at something, but perhaps you can have a rough estimate and a rough idea. It can help. Then I'll generally put an introduction section in. So what that definitely should include, in my opinion, is the decision that you're challenging. So you should specify that, and usually the date of it as well, and who made it. And you might then also, in the introductory section, wish to summarize your grounds. So you might want to list the headings out, or you might want to capture see if you can capture the essence of your case in one paragraph or one line. And if you can do that, that can, I think, be quite an effective technique, because what you want to try and do is hook the judge right from the outset to sit up and think, oh yeah, there is something of interest here, and to read it very, very carefully, and with a view to looking for something that's arguable. So if you can, it's a good thing to do. Because, as I said, you capture the judge's interest right from the outset. After that, there might be some procedural matters that you want or need to deal with in the application. So the most obvious would be issues relating to delay and issues relating to your client's standing to bring their claim. Now, it's not always clear where the best place to deal with those issues is in your statement of facts and grounds. So, for example, if it's a really obvious point that's going to be taken against you, and that, to be honest, the judge is going to be aware of even before they've seen any statement of facts, any response from the other side, then probably you should deal with it up front, because if a judge, if for example you brought your claim and it's obvious from the date that it's 6 years out of time, the first question the judge will ask is, well, isn't this out of time? Why do I need to even bother reading the rest of this? And they'll pay much less attention potentially to your actual grounds, because they'll just be preoccupied with the fact this is out of time. And if it's not till the end that you get to tell them, oh no, it's okay for this reason or that, you potentially missed a chance to just deal with that issue head on. So if it's a really obvious point, I would put it up front, and you'll usually know how big a point it is. If you follow the pre-action protocol, you usually know if the defendant's going to take a point about timing, or if they're going to take a point about standing, which is the other matter. But obviously, if it is less obvious, then it might be better to put it at the end of the document, after the judge has had a chance to read the substance of your claim and hopefully get interested in the substance of your case, because it may be that if you can interest the judge sufficiently in the substance of the case, they may take a more benevolent approach to more ambiguous questions about timing and standing. So it's a matter of judgment, really, about how you go about doing it. And just a further point on standing, even if standing is not a specific point, that's likely to be taken against you in the claim, you should, in my view, plead sufficient facts to demonstrate that your client does have the standing to bring the claim, just in case it's taken against you and just in case it's a point you need to rely on subsequently. It doesn't need to be long, but it's worth expressing what their interest in the matter is. Then, after you have done that, I would usually deal with the background facts. I generally do that chronologically because it tends to be the clearest way. But there might be occasions when that's not appropriate. It might be better to do it thematically. Perhaps there are various decisions in play. Perhaps there are different elements that it's just more appropriate to deal with separately. Again, a matter for judgment, but what you want to be is as clear and persuasive as you possibly can be. And that might include obvious stuff, but thinking about putting subheadings in just to break things up a bit. And again, add that sort of clarity for the judge. And in addition, you might want to think about whether specifically a chronology would assist the judge. And often I'd say it will. It can sometimes feel like an extra burden. You've done a lot of work setting out the facts, but a kind of one-page chronology as an annex or in the statement of facts can really help a very busy judge get to grips with the factual situation, especially if it's complicated and spans over a long period of time. And I'd also add to that, if you do end up having to go to a permission hearing, again, chronology is really, really helpful at those to quickly get a judge on top of the facts. So if you've already done it, it does save your job later, and I think it probably overall helps you get your point across. So do think carefully about whether that would be worth doing. And my general advice is when you're setting out your grounds, I would tend to avoid too much argument at this stage, if you like. So keep it relatively factual. What you want to do is set out the facts in a way that's going to set up your argument. So you obviously need to think about what your grounds are and what your argument's going to be. That way you know what facts you need to set out, and obviously you can put them in a way that will set up your argument. But what I would avoid doing is sort of repeating your arguments in the statement of facts or being too argumentative. Try to set it out as neutrally as possible. Obviously remember that you're also under duty not to mislead the court, but you want to be persuasive and you want to plead the facts in a way that's going to help you. Then, the other point to make about that is this is the point where you're most likely to want or need to cross-reference to other documents that are in the bundle. And so make sure you do that to aid the judge's reading, otherwise they might be a bit lost in doing that. So then typically what people will do, and what I would do, is put in a section on the law, a sort of legal framework within which the decision sits. And often there might be a relevant statutory framework that you have to set out in brief. You might need to cite the statute in full, but you might be able to summarise its operation and refer in the bundle to, or an annex to, the sort of full statutory provisions that you need to rely on. It's a matter of judgment. Remember, again, you want to keep things concise and clear. In terms of then, you might then want to set out any case law and other authorities that you rely on. Again, my advice is, rather than long quotations from cases, it's better to just try and state the principle of law which you're asserting, and then state the authority which best encapsulates that principle. And I say I think better to go with one very good authority than 10 okay authorities. Be selective, because you only need one authority. You don't want to overburden the court with references or with reading. But again, it's worth stating that there can be times where it's more convenient to set out the legal framework and your grounds sort of at the same time together, because each ground touches on a very discrete and different area of law, and it just aids clarity of reading. And that should be ultimately your goal, is what's going to make this as clear as possible for the judge. So then moving on to the grounds, this is obviously the key to your case. This is where you have to tell the court why the decision that you're challenging is unlawful, and persuade them that at the very least they should grant you permission to proceed with that claim. This is what it says in the practice direction. It should be obvious that each ground should be set out separately. It should be numbered. So typically ground 1, ground 2, ground 3. Sometimes people say A, B, D, A, B, C, D. It doesn't really matter, but usually using numbers is probably the most, well, clearly it is the most common, and that's what I'd recommend. Sometimes you might decide to break a ground up into different sort of subgrounds. For example, if you've got a number of errors around a common theme, you might decide, well, in a planning context, say you might decide that there's been an error in considering the impact of something on listed buildings, but that actually that error overall as a theme is manifested in perhaps several different issues or errors that you might want to sort of enumerate underneath that ground as sort of subgrounds. Again, just try to be as clear as possible. And on that theme, when you're pleading ground, it's very important to clearly articulate what the error is you're complaining about. So I would suggest I try to do that in a sentence in the title to the ground. So ground 1, the defendant failed to have regard to the following material consideration at this time. And then what you need to do is, once you've done that, just, again, set it out. What do you mean? So relevant or material considerations is a really good one. People often do this badly. So the first thing is, if you're going to say that somebody's failed to have regard to a relevant consideration, you need to tell the court what that consideration is specifically. Why is it irrelevant? As in, why is it a legally relevant consideration, something that's a matter of law they had to have regard to? And third, where is the evidence for them not having had regard to it? Where can you find that? And again, you can cross-reference there to the statement of facts, and you can cross-reference to the evidence that's in the bundle as well. And then finally, why does it make a difference that they failed to have regard to this consideration? Those are all points you need to think very carefully about. Questions the court will need you to answer, and you should answer them very directly, very clearly. The same with irrationality. For example, you're going to say something is Wednesday unreasonable. You have to say, why is it so unreasonable that no reasonable decision maker would have made that decision? And sometimes it helps us list reasons why. But you have to tackle your ground head on and be very direct. In my opinion. Think about what grounds are going to take, and obviously that should really be the starting point of this whole exercise. Is what are the grounds you have to challenge this decision? My advice is be circumspect. So don't take points that you think you won't win in the end. It's not in your client's interest because it might limit his ability to recover costs, for example. But also I think it can dilute your claim. So too many grounds can be a real turn off for the judge. It's laborious to go through, and it can dilute your good points. If 1 out of 10 grounds is a good point, it just makes it look worse than if it's 1 out of 3. Of course, you must take instructions from your client about what grounds do you want to pursue, and there'll be some that they insist on pursuing, but it is worth trying to advise and exercise your judgment on that. I tend to think that 3 or 4 grounds is a good number, but there is no magic formula, and so you will, as I said, you will have to use your judgment on it. But being circumspect, in my opinion and my experience, is a good thing to do. The other thing about your grounds is, unfortunately, and this can be really difficult for claimants who are very often in a hurry to issue judicial review, because first of all, it's a very front-loaded process, and second, the clock is ticking all the time on you. You need to think quite carefully about what you're putting in your grounds, because these are what you have to rely on both to get permission, but also at the substantive hearing. These have to see you all the way through to the finish line. So you don't want to close avenues down that might be useful to you, but also you don't want to be too vague and try to plead every potential error, or not want to be tied down too much as to what the error is. You have to strike a balance, and you have to think very carefully about it. Generally, I'd suggest being as punchy as you can with your grounds, because it makes it overall more persuasive. for the judge. And I try to aim for about a page per ground as a rough guide, because if you've done all the work before setting out the facts and the law, you shouldn't need much more to set out your grounds. So that's what I aim for. Again, no magic formula, and it does vary enormously. Just something to think about. Then finally, there's some other matters that you probably should deal with. So you should, indeed, you must deal with the question of relief. So you need to set out specifically what relief you're seeking. If you're seeking a declaration, what is the declaration you're seeking? If you're seeking to quash a decision, what is the decision you're seeking to quash? If you're seeking costs, say that. Then another issue you generally probably want to deal with to some extent is this question of whether you should be entitled to that relief, in as much as the test in section 31(2)(a) of the Senior Courts Act may apply. So the question of whether it's highly likely, if the error complained or hadn't happened, the outcome will be the same or substantially the same. More often than not, a defendant will plead that against you. So it's good to be slightly proactive about dealing with it. Now, you don't want to plead your claim too defensively, because it makes it look like you've got a bad claim, and it might invite the defendant to run arguments against you that even they haven't considered. But it's often good to show, generally at least, why an error that was made a difference. Why, if this all went back to the decision maker, it could actually make a difference. And again, you've used your judgment about how much detail you need to go into and how defensive you need to be. And if you've engaged in a pre-action protocol, that can often be a good guide to what points can be taken against you. Then there might be other things that you want to deal with. So, for example, if you're making a protective costs order, that might be something you want to put submissions in at the end of your statement of facts and grounds or in an annex. Same for anonymity applications and any other manner of application you might want to make. As I said, it might be best to deal with these at the end or in an annex, and then obviously pop your name and the date on, and then hopefully you're all done and you can file them. So they are some essential principles and some good general advice about how to draft grounds for judicial review claim, and I hope that's helpful. Thank you very much.